So, as many of you know, and some of you may not know, I wanted to share the good news. We at AsiliA Law Firm were able to get a conviction overturned for a client of ours, a very well-deserving client of ours. We got his conviction overturned, and how do we do it? We'll go over that in the next couple of videos, but I wanted to share with you just how we ended our brief. So we filed an initial brief in this case that was 50 pages long, and in the conclusion, I said the following: rarely are trials conducted in such an unfair manner. This brief could never capture all of the moments during trial that rocked Mr. DeCastro's belief in the judicial system to oblivion. Oftentimes, the law did not matter. Certainly, Mr. DeCastro's right to a fair trial did not matter in the lower court. Mr. DeCastro requests that his convictions be vacated and his case be remanded for a new trial in front of a new judge. And the 3rd District Court of Appeals did just that. They remanded his case for a new trial in front of a new judge, and Mr. DeCastro is coming home. Just so you know, when an appellate court remands a case back to the trial court, it means they're sending the case back to the trial court for the trial court to follow its instructions. And in this case, the instructions from the appellate court are that DeCastro is to get a new trial in front of a new judge. So what that means is we gotta pretty much start from scratch with the trial and hope that we get a better decision from the jurors this time around. So if you want to know, or if it's important to you to know a little bit about the history of Mr. DeCastro's case, I want to take you back to when I first picked up the case. Mr. DeCastro had been sitting in the county jail for 4 years prior to me getting on the case. He had multiple attorneys, maybe 3 attorneys that he had back to back to back, and for the course of 4 years, he never had a bond hearing. So he was sitting in jail with no bond, no attorney was filing a bond motion or setting it for a hearing. And once we got on the case, we immediately filed a bond motion, which is called an Arthur hearing, when you're charged with something that's punishable by life. We had this Arthur hearing, and we're able to get him out on bond. He's on house arrest. And a year later, we go to trial. But in that period where he was out on house arrest and we were able to go to trial, he was able to be free. He was able to, do things that he hadn't been able to do in the previous 4 years. And he was able to come by the office and prepare for his case and prepare for his trial, something that he would not have been able to do actually in the jail. It's a lot harder when you have clients in jail, when you want them to prepare for trial with you. It's just hard to get over to them, to call them on the phone and, hey, I need your opinion on this. I need to know your thoughts on that. It's difficult when they're in jail. So it was a blessing to have him out of jail prior to his trial. And I think it can't get lost on us, like what I'm saying here. An individual had lawyers for 4 years and did not have a bond hearing for 4 years. And you could be at home thinking, hey, how is it possible that somebody could go 4 years without having a bond hearing for their case? Or how could the client stand for that? How could the lawyer stand for that? Well, I'll tell you, clients typically don't and can't file their own bond motions. It's up to the lawyer. So if the lawyer is not willing to do it, if the lawyer is, for whatever reason, being lazy, just afraid to have the bond hearing, then you're not going to have the bond hearing. And so it's so important to have a lawyer on your team that's going to fight for you and fight for your rights, because there was no reason why he should have been sitting in the county jail for 4 years prior to having a bond hearing. But as soon as we got on, we were able to get him a bond. We've discussed that in previous posts. So yeah, I'm going through these pictures and it's funny because you could see how stressed we are in these pictures. There's a picture of me alone sort of sitting there. I don't even know who took these pictures. I think my intern took them at the time. Thank you, Justin. But yeah, I'm looking at this picture of just me sitting on the bench by myself. This is actually while we're waiting for the jury to finish deliberating. So it was 6 hours that they were deliberating, and it's painful because it's like the whole time that we're waiting for the jury to deliberate, it's just anxiety through the roof because of how serious the charges are and the consequences that could come from it. And so I'm sitting there probably like praying, that thing you do, God, please get me out of this. If you get me out of this, I'll change my life. And that's probably what I'm doing there. And I don't even have to change my life. I'm not doing nothing crazy. But yeah, then there's a picture with me and Eiffel sitting next to me. And he's stressed. You can see clearly he got his hand on his forehead, and anxiety for him got to be through the roof. He's the one that actually might be possibly going to jail. But yeah, that's when we were waiting for the jury to make their decision. And, I thought that we had done enough to win that trial, despite what was, in my opinion, a lot of unfair, back and forth with the judge. The judge at one point threatened to throw me in contempt of court She said that I was playing mind games with her while I was just arguing, for my client's rights and whatnot. But I mean, you can't quantify how important it is and how special it is that we got a case overturned and a new trial in the third DCA. So yeah, this case has been quite a roller coaster, ups and downs, but right now we're up with Eiffel coming home.